Beckett decision, the 1989 Colorado Supreme Court and the appeals court decision, People v. Beckett. They said there's no error where the court excluded evidence of actions of the victim after the actions and demeanor of the believed assailant which first occurred that are relevant. Another holding of the Beckett decision, the 1990 Colorado Supreme Court decision. Well, actually, the appeals court. The appeals court said that the appeals court said that self-defense could not be an affirmative defense to a prohibited use of weapons charge. And then the Supreme Court is going to go ahead and affirm that the defendant's tendered apparent necessity instruction was merely redundant. So the Supreme Court and the Court of Appeals say that if you say, well, it seemed like I should have defended myself, you're not allowed to tender an apparent necessity instruction. So, yeah, the Beckett decision is stupid and terrible. It's a Plessy versus Ferguson decision. It's a Dred Scott decision. People v. Beckett. So let's talk about the case. The case itself, you just got this tiny little blurb. In May 1987, the defendant and his friend, this is going to be Beckett. So Beckett, while they were attending a party, they became involved in an altercation. They don't mention what the altercation is. So not an argument, an altercation. With Ralph Cirillo and two of his friends. So you got Beckett and his friends, and you got Ralph Cirillo and his two friends. It's 3-on-2. As the defendant leaves the party, Cirillo and his friends follow Beckett and his, friend. I'm not for sure where his friend is. And when Cirillo and his friends followed Beckett, at least, to his car, Beckett raised his hand up and said that you're this close to death. When the defendant reached his car, he reached under the front seat, pulled out an automatic pistol, and pointed at Cirillo. And he stated, "This is all it takes, pal. This is all it takes." Right after that, the defendant was disarmed and restrained until the police arrived. So there's a lot of shit that happened there. Now, Beckett is going to testify at the trial that Cirillo and his friends were very large people. They were angry, and he was afraid that Cirillo and his two friends would harm him. Now, there's some places where they say that you got to look at the case in the light of the prosecution, in the light that's favorable towards the prosecution, such as a preliminary hearing. But I don't understand this. Why? If we're innocent until proven guilty, you would look at the case in the light of the defense if you were being fair. And it seems crazy that you got big, angry Ralph Cirillo and his two big, angry goons. They're being dicks at a party. Beckett tries to leave. Ralph Cirillo and his two goons suspiciously follow him. I don't know if Beckett's friend was there or not. He tells that they're this close to death, pulls out an automatic pistol, points it at Cirillo. "This is all it takes, pal." Then the three goons attack Beckett, take his gun away, hold him down, and then call the police. But that's if we only consider one side. How are we only going to consider one side and not the other? So if you're a fair person, you would consider both sides. So Beckett tried to leave the party. If you're the assailant, you have a duty to retreat. So let's assume, Beckett was starting shit. Didn't seem like it. Actually, let's assume Ralph Sorella was starting shit. So you got this bully who's starting shit. It's 3-on-2. So in the world of the chimpanzees and the state of nature, 3-on-2, that's a threat. So he's leaving. He's walking away. Even if he was the asshole, he's doing what he's supposed to. But Ralph Sorella, nah. Beckett got the better end of Ralph Sorella and his two goons, so they have to follow him out to his car. And he's kind of like, what are you following me for? There's a clear physical threat. Ralph Sorella and his two goons meant to do him harm. And guess what? They did. They put their hands on Beckett, take away his gun, hold him down. They called the police. Only in that respect were they being lawful. But again, why were they following Beckett to his car? Clearly he felt like they were a threat to him. So it wasn't like he's like, you know what, I'm just going to go to this party and, point a gun at somebody. He's trying to walk away. And like I said, in the end, they were a threat to him. They arrested him. They got him to a cop car. They imprisoned him. They put charges on him. It's one thing to be a complete, perfect victim. You're just sitting there by the tree, reading a book, minding your own business, and then people started fucking with you. But it's another altogether when you provoked the guy, and you stalked him, you harassed him, you menaced him, for the ends of putting your hands on him, taking away his freedom, putting charges on him, imprisoning him. There is a principal in Kentucky. He said typically when students get into a fight, he would punish both of them. And he made it sound like he did it for every fight, for all the fights. Why? Because at the very least, the other one was jawing. He was running his mouth. He was jawing. Even if one was worse than the other one was doing something provoking, something crappy, they were jawing. So for this principal in Kentucky, he had some sense of they're both in the wrong. And it's always like that. It's always the case. So that's, probably too much. But he's saying that both are responsible to some degree. And so, yeah, when it comes to the Beckett decision is a terrible decision in Colorado jurisprudence. The conclusions that they come up with is terrible. There's this one, he wants apparent necessity. So, and then the argument in Beckett is that apparent necessity is already embedded in the laws, is already embedded in instruction number 14. And so, therefore, apparent necessity was already a tendered instruction because it was already, but you have a right, if you're in the defense, to put forth a theory of your case. And so, if they didn't, there was a dissent to this decision, a great dissent by Schoenberg, Kirschbaum. The Kirschbaum dissent said that if you didn't have alternative instructions, then you had to give the defendant's instructions. He says that apparent necessity is a part of self-defense. It's embedded in the laws, which the majority of the court agreed with. And this was the great Rivera decision, too. Chief Justice Rivera. He was the first Hispanic Supreme Court Chief Judge, something. So Beckett is going to be convicted of felony menacing with a deadly weapon and prohibited use of weapons. Prohibited use of weapons, so he's using a weapon that he wasn't supposed to use. So that, wasn't at issue. It was felony menacing with a deadly weapon, 183206, C.R.S, 1986. So according to the dissent, the Kirschbaum dissent, if you're not going to tender apparent necessity defense, then you have to have some alternative that, best explains it in a different wording or some shit. All you did was say that the defendant wasn't allowed to defend himself. Even in goddamn court. Couldn't defend himself at the party, couldn't defend him out in the streets, defend himself in the streets, couldn't defend himself in court. So Kirschbaum dissented and said, I think that this should have been reversed. It's clear that, they did Beckett dirty. The court did Beckett dirty. And you know what? If I want to take it another step farther, it's kind of crazy that Ralph Cirillo is sitting there, suspiciously following Beckett to his car. And maybe his friend is there or not. Beckett, tells them to leave. That's a command. And then the next thing is hands in the police's continuum of force. And then it's, taser, and then it's gun. So, yeah, the Beckett decision is a terrible decision. It's a terrible decision because apparent necessity, you're not allowed to tender it as a defense in Colorado because of the Beckett decision, but it's a terrible decision. The dissent, Kirschbaum's dissent, says you are allowed to put apparent necessity into the instructions. So, yeah, fucking Beckett decision. I have a right to defend myself. Well, you're not allowed to say it out loud in court. What? I mean, you have a right to defend yourself, but you're not allowed to say that out loud. You got to keep that quiet and to yourself. So, yeah, fuck the Beckett decision. Fuck the Beckett decision.